Straight ahead on Law&Crime Daily. Prosecutors take jurors through another crime scene in the Pike County Massacre.
Were you able to say, looking at him there, whether he would have been awake or asleep, or is there a way to determine that?
Again, in my opinion, I would say he was asleep.
And the Parkland school shooter penalty phase trial.
I find that the prejudice with the word swastika in the drawings does not outweigh the probative value.
The judge partially grants motions to introduce certain evidence as the prosecution prepares to present its rebuttal. Plus,
I would like to speak to the officer in person, but what we have found is we've actually discovered 2 dead bodies.
911 calls are released after 2 teenagers are found murdered in the woods of North Carolina. And later, jury selection begins in the love triangle trial of Nikki Sue Entzel, who faces conspiracy charges after her husband was shot to death and burned inside their home. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm your host, Brian Buckmeyer. Week 3 of the Pike County Massacre trial begins as investigators describe yet another crime scene in the deadly shootings. George Wagner IV faces multiple charges, including 8 counts of aggravated murder for his part in the Pike County Massacre. In April of 2016, 8 members of the Rodin and Gilly families were found murdered, many as they slept. 3 children were left alive. Members of the Wagner family were arrested in connection to the murders years later. Parents Angela and Billy were arrested along with Edward Jake Wagner and George Wagner IV. Angela and Jake admitted to the murders, saying they hatched a plan to be granted full custody of the child Jake shared with Hannah Rodin. Jurors are now hearing about the murders one crime scene at a time. On Monday, prosecutors focused on the crime scene where Kenneth Rodin was found murdered. Experts say there was no sign of a struggle and it appeared as though the victim was asleep.
Recalling your time at the scene that day, does the blood flow suggest anything to you pursuant to your training and experience?
In my opinion, that was the position that he was shot.
Were you able to say, looking at him there, whether he would have been awake or asleep, or is there a way to determine that?
Again, in my opinion, I would say he was asleep.
Okay. What was your purpose in taking blind swabs from our victim's hands in this particular case?
To see if anybody would have grabbed or restrained his wrist during any time in an altercation.
And looking at the scenes that you saw that day, did you see any signs of a struggle, altercation, anything like that?
No.
But in such a case, though, just in case, and to be absolutely sure, you still take blind swabs then?
Just as a precautionary measure, you get one chance at getting evidence, so.
This BCI testimony comes just weeks after jurors heard the emotional testimony from Donald Stone, the cousin of Kenneth Rodin. Stone got emotional on the stand, describing what happened when he found his cousin's dead body.
I noticed to the right, I didn't see him in there nowhere, so I seen a stairway to the right, and I walked up the stairway, and that's where I found him, up there in his bed.
And when you say you found him, who did you find?
I found Kenny.
Can you tell us what condition you found him in?
He had blood all over his eyes.
And where was he located?
In his bed.
Okay. Did you believe him to be dead or alive at that time?
He was dead.
Joining us today is criminal defense attorney Bernardo Villalona and co-host Terry Austin. Bernardo, Kenneth's cousin testifies about finding Kenneth's body. Then the BCI investigator describes the crime scene. Is there a strategy as to how the prosecution is presenting the evidence?
Well, what the prosecution is trying to lay out is as much corroborating evidence as they can, because remember who's going to testify against the defendant, his mother as well as his brother. So they need to corroborate as much as they can of their testimony, because when they take the stand, first off, they're going to be nervous as to whether they willingly are going to fully cooperate and say what happened. And second, if they do, they need to be able to corroborate for the jury that what they're saying is the truth.
Yeah, the more people are saying the same thing, the tighter the case becomes to the prosecution. Terry, Agent Staley did not live in the area. Do you think that makes a difference in the overall investigation?
I do. I think it might make it a little bit more difficult. If you recall, Agent Henshaw, who was on the stand for quite some time, he processed that first crime scene. He knew all of the other officers, all of the other agents. He was very particular. And then Agent Fortner, he processed the second crime scene, and he knew Henshaw, and he actually was able to use his laser scanner for the first crime scene. So they all worked together, and they knew the area, they knew the neighborhood, they knew the people. So Agent Stanley, I'm certain he did a great job, but he didn't know everyone. He didn't know the area, and he didn't know the other agents. So I just think that if he had been in the area, he could probably process that scene a little bit better, a little faster. It's something the Cross could probably focus on as far as some weaknesses in the case. But as it turns out, I think he picked up the evidence, he processed it, he did a good job, and they needed him. They needed people from outside the area because so many people had died.
Yeah, maybe it kind of speaks to the atrocities that this community is facing, that the murders were so huge and so big in number and scale, they needed people from outside the community to help. Well, we'll see what the jury does with that information. From the Pike County Massacre to the Doomsday cult duo, as an Idaho judge bans cameras from the upcoming trial of Lori Vallow Daybell and her husband, Chad. 7th District Judge Stephen Boyce made the ruling on Friday, citing that news organizations will no longer be able to take pictures or videos inside the courtroom in this case, and that he feared the images could prevent a fair trial. Last month, Lori Vallow Daybell's attorney asked the judge to ban cameras from the courtroom after they say one news organization abused the privilege by repeatedly zooming in on Vallow Daybell's face during an August hearing. At the time, Vallow Daybell made headlines for smiling during her hearing. Vallow Daybell and her husband are charged with conspiring to kill Vallow Daybell's youngest 2 children and Chad Daybell's late former wife. Both have pled not guilty to charges which carry a potential death penalty. Still ahead on Law and Crime Daily, the chilling 911 call released after 2 North Carolina teens are found murdered. But first, the Parkland school shooter. Days before the prosecution begins its rebuttal case, the judge makes a ruling on what evidence can be included. Welcome back. As the prosecution prepares for its rebuttal case, the judge makes a monumental ruling on evidence in the Parkland school shooter penalty phase trial. After pleading guilty to 17 counts of murder and 17 more counts of attempted murder, the shooter now faces a sentence of life in prison or the death penalty. Weeks after the prosecution motioned to include controversial evidence, Judge Elizabeth Schreier ruled partially in their favor. According to court documents, the judge noted that while some material may be prejudicial, it is relevant in rebuttal to a key issue of the defendant's mental health diagnosis. That means prosecutors can include images of swastikas on the defendant's AR-15 and boots. They can also include 20 examples of the defendant discussing hate speech, racism, animal abuse, or child pornography on the internet. That number is down from more than 400 examples of the defendant's search history. On Tuesday, jurors are due back in court as the prosecution is expected to begin its rebuttal case. Terry, do you agree with the judge in what is and is not coming in?
I do, Brian. I definitely think she made the right decision here, and I think she was very careful to carve out just exactly what can and cannot come in. The swastikas, like she said, they're relevant because they do go to show his mental health, and it shows the hatred that he harbored. So I definitely think that they should come in. And frankly, they were on the boots and they were on the gun. The boots and the gun were at the scene, at the crime. That should be shown. And I think that the other, derogatory comments, the racial slurs, that should also come in because, again, it's definitely showing his mental health, his state of mind, the fact that he had hatred in his heart, and that goes to damages. And she was correct when she didn't let hundreds of pictures and other things on social media in, but she did let, dozens in. It's going to answer the question as to whether or not any of it is redundant. And I think that's going to help the prosecution. The prosecution doesn't want the jury to get bored. So even though she limited, I think it's going to be helpful to the prosecution.
Yeah, I would agree. I don't see any of this being helpful to the defense, but let's ask Bernarda. Bernarda, how much will these images change the direction of the trial, and will it greatly damage the defense's case?
I think it definitely changes the direction of the trial because remember the jury they want to know why. How can a man shoot 34 people, killing 17 of those people? And now you're giving them a why that they did not know at the beginning of the case, during the prosecution's case, and during the defense case, and they're not going to hear until now the rebuttal. It makes you look at Nicholas Cruz completely different because now you know that he has more hate in his heart and that he's been looking into all this different type of hate, especially to the point where he's walking around with a firearm that has a swastika on it, as well as his shoes. So it definitely changes the perspective of how you view this case and how you view Nicholas Cruz.
Yeah, we'll see that perspective as it changes in Morris as the jury does get to hear the case on Tuesday. In federal court, Elizabeth Holmes' sentencing is delayed until October as her team works to score her a new trial. Prosecutors, though, say their reasoning is not grounds to have a conviction thrown out. As Law&Crime Daily reported, a former Theranos employee who testified against Holmes showed up at her home in the weeks before sentencing. Defense attorneys say that's grounds for a new trial, but prosecutors disagree. In a motion filed earlier this month, defense attorneys say former lab director Adam Rosendorf went to Holmes' house last month after requesting a meeting with her lawyer. Rosendorf allegedly met and had a conversation with Holmes' partner, William Evans, in their driveway, expressing regret over his testimony. However, in a sworn declaration, Rosendorf stood by his testimony and refuted the defense's assertion that the government did anything more than encourage him to tell the truth. Elizabeth Holmes was convicted earlier this year on 3 counts of wire fraud and 1 count of conspiracy to commit wire fraud. She's due back in court on October 3rd for a hearing to discuss Holmes' motion for a new trial. Right now, she is scheduled to be sentenced on October 17th. Coming up on Law&Crime Daily, after multiple delays, a North Dakota woman accused of conspiring to murder her husband is heading to trial. Plus, a North Carolina sheriff's office releases the 911 calls in the deaths of 2 teenagers who were found murdered. We'll have what the callers said on the other side of the break. Welcome back. We head to North Carolina where officials released 911 calls in the murder case in which 2 teenagers were found shot to death last weekend. 18-year-old Devin Clark and 14-year-old Lyric Woods went missing Friday, September 16th. 2 days later, the high school students were found shot to death along a hiking trail by men riding ATVs in the area. Investigators believe a 17-year-old was responsible. That teenager, whose name is not being released due to their age, faces 2 counts of first-degree murder in a juvenile summons in the shooting deaths of the 2 victims. In North Carolina, 16 and 17-year-olds who commit crimes are not automatically charged as adults, but the case could be transferred if there's probable cause. Officials have released the 911 calls from when Clark and Woods were discovered.
Orange County 911, what's the address of the emergency?
I guess the officers probably need to respond non-emergency, but it is a pretty serious issue. I would like to speak to the officer in person, but what we have found is we've actually discovered 2 dead bodies.
What's the address as to where you found the bodies?
There's not an address. It's kind of, there's no house where we found the bodies.
Exactly where are the bodies?
There's an access to like where the power company cut a road in, and they're just laying around on the side of the road.
Terry, what does the prosecution get from the 911 call that could lead to a conviction?
Well, fortunately, that person did come across the bodies because they were only there for 2 days. If it had been much longer, some of that evidence might have disintegrated. But they couldn't provide an address, but they did take the authorities back to those bodies. Apparently, if it was a boy or girl, I don't know, because the voice has been changed. It leads me to believe that it's a young person, and they had to go home to the father to say, what should I do? And the father said, call 911. and then they directed them back to the scene. So the good news is someone found the bodies. The bad news is it doesn't seem a lot of evidence on that scene just yet, or we haven't heard any of the evidence reported, whether or not the bodies were dragged, whether or not they were walking out there, whether or not there were tracks from tires. So we'll learn all that information. But I think the best thing that we know right now from that caller is they found those bodies.
Yeah, and exactly when and what time they found it as well. Bernardo, the suspect is who's going to be charged as a juvenile. At first, we hear that it could change to being an adult. So what do you think is going to happen when the suspect is found? Charged as a juvenile or as an adult?
Well, given that we're talking about two homicides, whoever the person is that is found is going to be charged as an adult, given the violence that occurred in order to lead to these deaths. So, even in New York, so you can be arrested as a juvenile, but when you're talking about certain acts of violence, they make an application to the court to actually charge the juvenile as an adult and prosecute them as an adult, which changes the whole scheme of things in terms of what type of sentence you can get if you are convicted.
Yeah, and even in New York, that really comes down to often how you brandish a weapon and use it violently. I would assume in a case like this, as you said, Bernard, a double homicide, probably charged as an adult. When we come back, it's North Dakota versus Nikki Sue Entzel. We break down Law and Crime Network's newest live trial as Entzel stands trial in connection with the murder of her husband. Welcome back to Law and Crime Daily. New details released in the Kristin Smart murder trial reveal one of the defendant's attorneys may have been working on a plea deal. The trial of father and son, Paul and Ruben Flores, is underway in Salinas, California. Prosecutors say Paul was the last person seen with Smart, who disappeared in 1996. They say his father, Ruben, helped conceal Smart's body. She was legally declared dead in 2002. Newly unsealed documents show Paul Flores' attorney may have been working on a plea deal back in 2010. The court documents reveal Paul Flores' attorney told investigators his client could lead officials to Smart's body in exchange for a plea deal. More documents reveal allegations against Paul Flores of sexual assault, rape videos, and child pornography. And in North Dakota, jury selection begins in the love triangle murder trial of Nikki Sue Entzel, who was charged in connection to the 2019 murder of her husband. Investigators allege Entzel was having an affair with a man named Earl Howard while she was still married to her husband, Chad. In late December of 2019, officials believe Entzel and Howard conspired to kill Chad after filing a $26,000 property insurance policy on the home she shared with her husband. In the early morning hours of December 31st, Entzel and Howard allegedly shot and killed Chad in the master bedroom of the home with a shotgun. Days later, firefighters and police responded to Entzel's calling 911 about a fire at the home. Investigators believe the two started the fire to cover up evidence and burn Chad's body. Police couldn't determine if it was Entzel or Howard that pulled the trigger killing Chad, so they were both charged with conspiracy to commit murder, among other charges. Howard pled guilty to conspiracy and arson charges and was sentenced to 25 years. A jury of 12, along with 4 alternates, will be selected to hear Entzel's case. Bernard, opening statements haven't begun yet, but what do you think the defense in this case is, and is it believable?
Well, the defense in their opening statements should make no promises to this jury. I think they need to keep it very general in saying that keep an open mind, do not make a decision, wait until all the evidence and lack of evidence has been presented, and wait until after closing arguments and jury instructions before they can sit down and make a final determination in this case. If you keep it simple and just say that the prosecution has to meet their burden of proving their case beyond a reasonable doubt and that their client is presumed to be innocent, I think you leave yourself open for so much possibility and so much different trial advantages doing the trial where you're not committed to just one strategy.
Absolutely. The conspiracy aspect of it really intrigues me because the prosecution said we don't know who killed them, but we're not charging anyone with killing, just conspiracy. Terry, love triangle, convicted boyfriend, and a $26,000 insurance policy. Is this a strong case for the prosecution? Murder for money and love, perhaps?
You bet it is. No question about it, Brian. And for all of the reasons you just stated, there's a motive here, that love triangle. There's the money motive. And even though $26,000 is not a lot, we have seen that people have killed for less. And they have the opportunity here. They have access to that home. It's his wife. They are in the house together. She could do it at any point in time. And they have the means. So they have the motive, the opportunity, and the means. Apparently they had a gun, or whatever they had was able to, shoot and kill him. And they started the fire, allegedly, to cover it up. So I think the charges that are pending now against her could actually be higher. And I think there should be more evidence to say there was actual murder, not just conspiracy to commit the murder, conspiracy to commit arson, and conspiracy to tamper. They have more, I think.
All right, well, this is another live trial that Law and Crime Network will be following. Make sure to check it out. Thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.